Welcome everyone to the GC3 Startup Network webinar on enforcing your patents. We will begin shortly, just allowing a few more minutes for people to log in. Thanks. We'll give everyone just another minute to log in and then we'll get started. All right, I think it's time to go ahead and get started. We appreciate your time today and want to make full use of it. So welcome to the GC3 Startup Network webinar, Enforcing Your Patents. This is the third webinar in a three-part series devoted to patent law. My name is Julie Manley and I'm the coordinator of the GC3 Startup Network. The Green Chemistry and Commerce Council is a cross-sector business-to-business network of companies and organizations working collaboratively to accelerate green chemistry across sectors and supply chains. Our GC3 members are champions and innovators, as you can see from the more than 120 members across the value chain. This webinar today was organized as a part of an initiative within the GC3. Actually, the initiative is the GC3 Green and Bio-Based Chemistry Startup Network. The goal of our network is to support green and bio-based chemistry startups, but also to introduce the large strategics in our network to new chemical technologies, as well as partnership and investment opportunities. We now have over 25 companies that are members of the GC3 Startup Network, and we continue to sign more on. These startups are able to tap into our network of large strategics through our mentoring program, or as we call it, our Strategic Connections program. And also, our startups can also participate in our technology showcases, where we bring together startups to present to and network with our large corporate members. And these startups can participate in workshops on key issues such as leveraging partnerships to accelerate innovation. Our next technology showcase will be at the GC3 Roundtable on May 8th, which will be hosted by Eastman Chemical Company in Kingsport, Tennessee. New this year, the technology showcase is integrated into the GC3 Innovators Roundtable rather than the day prior, as was done in previous years. We will have 10 startups with technologies that match interests of the large GC3 members. These companies have been selected to present their technologies to the full GC3 audience. Registration for the GC3 Innovators Roundtable, which is again May 8th through 10th, is now open on our website. So as we transition to today's webinar, I just want to quickly go over some logistics. Again, due to the number of participants in the webinar, all lines will be muted. If you have a question or comment, please type it into the questions box located in the control panel. And you can type in a question at any time. Earlier the better, but any time is welcome, so we can work to integrate those questions into the Q&A at the end. All of the questions, as best as we can get to them, will be answered at the end. And again, the GC3 network is very pleased to be able to bring you this three-part webinar series on patent law. Today's webinar will focus on key considerations and strategies for enforcing your patent rights. I'm pleased to introduce Shayna Sear, the moderator for today's webinar. Shayna is a partner with Finnegan, Henderson, Farabow, Garrett, and Dunner. Shayna has a BS in chemistry from the University of Richmond and a PhD in chemistry from the University of Virginia. She then obtained her Juris Doctorate with high honors from Rutgers University School of Law. And then with her combined scientific and legal expertise, she now represents clients in complex patent litigations, proceedings before the U.S. Patent and Trade Office, and appeals related to a variety of chemical products, including pharmaceuticals, biologics, combination products, diagnostics, and medical devices. So thank you, Shayna, Eric, and Denise for offering to present today. I will hand it over to you, Shayna.
Thanks, Julie, and welcome everyone. I have enjoyed becoming part of the GC3 network and look forward to seeing many of you at the roundtable in May. It is my pleasure to introduce today's speakers, my friends and colleagues, Eric Fues and Denise Main. Eric and Denise are partners in the chemical practice group at Finnegan, and they each have vast experience in helping clients enforce their patent rights. Eric represents clients in domestic and international technology disputes and leads our firm's chemical practice group. Eric has been involved in more than 50 district court cases and ITC investigations, and he also represents clients before the U.S. Court of Appeals for the Federal Circuit and provides client counseling. Intellectual Asset Management Patent 1000 has recognized Eric for his technical expertise and for having a presentation style as elegant as his writing. Denise holds a PhD in organic chemistry from the University of Florida and began her career in the field of green chemistry, designing new hydrogen storage materials at Pacific Northwest National Labs. Now a patent litigator, Denise's practice focuses on protecting patent rights in the U.S. District and Appellate Courts. Her legal experience includes matters relating to pharmaceuticals, cosmetics, hair dyes, pesticides, packaging materials, polymeric materials, and drug delivery systems. Her broad experience includes arguing dispositive motions, taking and defending witnesses in court, drafting trial and appellate briefs, conducting U.S. and foreign prosecution, and preparing patent applications and license agreements. Eric and Denise, welcome. The floor is yours.
Thank you very much for that introduction, Shayna. I appreciate the opportunity to speak to GC3 today, and I hope that our presentation will be educational and informative. And I will start off, as many lawyers do, with a disclaimer. Anything we say is for educational purposes today, and it does not constitute legal advice of myself, my firm, or anything else that could get me in trouble. So our topic today is enforcing your patents. Patents are actually described in the U.S. Constitution. They are considered discoveries under Article 3 clause of the Constitution. They actually carried over from England. Patents have been important in our federal system for many years. It used to be that U.S. presidents would actually sign patents. Andrew Jackson, I've seen some patents of his. John Adams signed patents. At some point, there were too many patents, so the president delegated that to someone else. I think this year we're actually going to have the 10 millionth patent. And I think it would actually be kind of amusing to have people in the White House who had to essentially stamp the president's signature on 10 million patents. They would keep them busy all the time. Now, patent litigation occurs in the federal district courts in the United States. They have jurisdiction over patent disputes, and that's a good thing. People try to get into federal court, and the reason they try to get into federal court is the judges are high quality, and if you have a serious dispute that needs to get resolved, The federal judges and juries in some cases will help you do that. Some of the very popular places to bring patent suits are the District of Delaware, the Eastern District of Texas, and the Northern District of California, but there are specific and sometimes complicated rules about where you can bring your lawsuit. It is the case, however, that once you're in federal court, if you appeal the decision, the U.S. Court of Appeals for the Federal Circuit, which sits in Washington, D.C., will hear the appeal, and also occasionally the U.S. Supreme Court takes up patent cases. Sometimes years go by when they don't take any patent cases, and sometimes they take several in just one term. I think they've had more activity in this area recently. In parallel to district court proceedings, there's also the possibility in patent cases to have a case at the U.S. International Trade Commission. This is a government agency. It's located in Washington, D.C. And as opposed to the district courts, the ITC, as it's called, has jurisdiction over imported products. So the basis for jurisdiction and making rulings is that foreign companies want to export products from their factories that are imported into the United States. And those imports, those things are what give jurisdiction to the ITC. The ITC is charged with protecting U.S. industry from unfair methods of competition by foreign entities. And it generally follows the patent law, but it has an additional requirement that whoever brings suit in the ITC needs to have a domestic industry in the U.S. The genesis of all this is actually the Smoot-Hawley Tariff Act of 1930. And some commentators actually think that's a bad act and that it contributed to the Great Depression. But as with many things in Washington, things live on here and then they kind of morph and take on a new form. So the ITC is actually charged with enforcing patent law through this Smoot-Hawley Tariff Act of 1930. So preparing for litigation. Now, I think you would expect a patent lawyer to say the first thing that needs to be done is to get the best patent claims possible to assert against the other side. And that's absolutely true. You're not going to win if you don't have good patents. There are other steps that are involved before suing also. They're closer in time to the lawsuit from when you got the patent, but they involve pre-litigation investigations, developing and maintaining litigation themes, and effectively managing communications. And all this needs to be done even before the lawsuit starts. And one of the things that you need to think about if you're considering enforcing patents is really how do you know if you have the best patent claims? The real challenge in this business is the companies and inventors have many inventions. Some of them become commercially valuable, some of them don't. And at the time that you're prosecuting patents, you really don't know which one necessarily is going to be commercially valuable. So it takes a lot of peering into the future and trying to think about the future in terms of the patent coverage that you get for any given discovery that you have. I kind of liken my job as a technological archaeologist. It seems like all my cases involve patents that were prosecuted and obtained maybe 10 years ago, 8 to 10 years ago. And it's only now that the commerce and sales and the marketplace has caught up and some of those patents become very valuable. In terms of obtaining the best patents and the best claims that you can use, particularly as a plaintiff, you need to try to get claims of varying type and scope. You need to claim any commercial embodiment that you're aware of. If you have a commercial embodiment, you need to claim potential variations of that. You want to try to claim potential variations of your variations. And you use a variety of different claim scopes to try to protect your invention from other companies who have very smart scientists, very smart researchers, and they might be able to figure out just on the edge of a narrowly claimed invention how they can work around your patent and it's not a problem. So that's why you want to obtain claims of broad scope. I can give you an example. There had been a company that was very skilled in developing separating out enantiomers of chemicals, the right-hand molecule from the left-hand molecule. And what this company did is it filed, and sometimes only the right-hand molecule or the left-hand molecule had medical applicability. The other molecule, essentially, for some drugs that these were directed to, didn't really have medicinal effect. But it was hard to know which, at the time of the invention, which side, which right-hand or left-hand molecule was going to be commercially valuable. So in that case, the patent attorney encouraged the company to file patent applications on both sides, on the right-hand and the left-hand molecules, and capitalize on their ability to separate out these chiral molecules. And at some point in time, technology made it easier to figure out whether the right-hand or left-hand molecule had the medical effect, and the molecule that didn't have the medical effect was dropped, and that was not continued to be prosecuted, and the other ones continued through prosecution. And they actually had a very profitable business that they obtained because of this. There's an old joke in patent law that patent lawyers are responsible for 50% of all inventions that are out there, and that is precisely because they will push their clients and stretch their clients to claim these variations that we're talking about here on the slides so that you have broader patent coverage. Now patent claims can have a variety of scope. I think the classic, particularly in a chemistry context, the classic might be a composition where someone has invented a new form of a chemical compound. So that would be on the bottom right-hand corner of the slide. But claims are not restricted to just the simple composition. There can be methods of using it, say methods of using it in the treatment, medicinal treatment of patients. There can be means plus function claims, which is a different claiming format. It's used sometimes when claims are difficult to describe. Perhaps they are, the terminology is a little bit hard to understand. It used to be that they were considered very broad claims. Because of some decisions, they're considered narrow claims, but the pendulum in the law switches back and forth, and at some point in the future, they could be broad claims again. You can get patents on processes of making that composition if there's something novel about the process, and you can even get something that's called product by process, which mixes the process and the product together in terms of a claim. So there's a variety of ways of getting claims surrounding the basic invention. And a good strategy, if you think you have a very commercially viable candidate, is to try to get different types of claims around that to protect yourself. Now, a little bit more towards the litigation side, and this is the pre-litigation side. An important issue in U.S. litigation, patent litigation, is discovery. And discovery is when parties exchange documents back and forth. And one of the important things that it certainly occurs at a certain point in time is that companies realize that because either they've been sued or because they're reasonably certain they're going to be sued or they're reasonably certain they might sue someone else, they institute what is called a document hold. That means that they actually hold and sequester documents. You can do it electronically, and you are not allowed to delete the documents that are part of this document hold because they can later be used during discovery. So it's a very important first step if you're seriously preparing for litigation. Another important step is to identify, and potentially even before the lawsuit starts, retain potential experts. Expert witnesses are vital in patent cases, and that is because the terminology and the technology is going to be difficult for a judge to understand. It's going to be difficult for a jury to understand. It's probably going to be difficult for the lawyers to understand too. So it is important to obtain an expert in the field who can try to explain that technology in simple terms so that you can prosecute your litigation, you can educate the judge, and you can educate the jury. Sometimes there are just a limited number of people who have expertise in a certain area. And it can be beneficial to try to retain several of those, particularly if you want to work with them either on a consulting or testifying basis, or if you don't want the other side to work with them, but you still think you could have a role working with them yourself. I had a litigation several years ago where one of the issues was dating a document in terms of the date of ink on the paper. When you write with a pen, the ink can be dated to a certain extent. And we had retained 3 experts in ink dating. And the other side complained when the litigation actually commenced. And they said that we had retained all the best experts in the whole country in ink dating. Of course, we disagreed and they eventually found another expert. But you do want to put some time and effort into identifying your expert witnesses because they're going to prove very important in the case. And there are other people that are going to be very important in the case too. And you want to identify them and interview them ahead of time, even before filing suit. One is the inventor, of course, or the inventors. There could be declarants who submitted declarations during patent prosecution. Perhaps they're people that work with the inventors and they're trying to support experimentation to provide a date of invention or something like that. There are also technical people on the client side who have just fundamentally very complete knowledge of the field of technology. In my experience, the internal technical people at the client, they really pretty much know what other people in the industry are doing. They know what approaches those other companies have taken, and they have a very good grasp of just the basic technology that your lawyers are never going to have because they don't work with that technology every day, and every case to a certain extent is new to them. So the technical people on the client side are always very important. And you're also going to want to interview the attorneys who are involved with prosecuting the patents. Some of those attorneys could be in-house at the client side. Some could be their outside lawyers. But they will have run across information. They will have provided certain information to the patent office. They might not have provided other information. You need to understand ahead of time why those attorneys did what they did. A lot of patent litigation relates to documents. I remember, years ago trying one of my first patent cases, and the lawyers were saying, we're going to have a paperless case. We're going to have a paperless trial, things like that. Well, it hasn't happened yet. There are a lot of documents that are important in patent cases. Perhaps there always will be because that's how people save and provide evidence of certain things that are important. Some of the key documents are invention records, for instance, an invention disclosure form at the company. There can be lab notebooks that have working examples of different embodiments of what is later claimed in the patent. And those will have certain dates on them, and that's very important for prior art purposes too. There are inventor publications. A lot of technical people and companies have an incentive to publish about their discoveries because they're excited about it. They want to be on the cutting edge of technology and things like that. And there's a little bit of tension between that and the patent law, which at least until more recently, you didn't want an inventor publishing anything until at least you got your case on file. I think that's probably still good advice. There's other things like regulatory filings you might want to look at. Companies, particularly in the pharmaceutical field, or even generic competitors in the pharmaceutical field, may make different representations to the FDA than they make to the patent office. So, it's important to understand what representations have been made in one form versus the other, because you're going to hear about it later in litigation. There are a variety of other files that are important too. Some of patents are essentially prosecuted in many different countries around the world, and those files need to be gathered and reviewed. And essentially other documents that might bear on validity or enforceability of the patents are important too. There could be issues of prior sales. There could be a variety of things to be concerned about. So with this brief introduction, I will turn the microphone over to Denise, and she will discuss potential challenges from accused infringer.
Thank you, Eric. So Eric just touched on a number of steps that needs to be taken, collecting documents and interviewing key witnesses and collecting key documents. And this is all important in terms of preparing yourself early on before you even file suit in selecting the best patents to assert during the litigation. What are the best patent claims to assert during the litigation? Which which of those claims are going to withstand a validity challenge of anticipation or obviousness or an enforceability challenge. And so becoming very close to the invention and with the inventors and knowing the story beforehand is going to help you prepare for these challenges. Now, in preparing for validity challenges, another thing to do is to go back and look at the prosecution histories of the patent applications before they were issued. Usually an examiner in the patent office will do a thorough research and find any anticipatory art or art that can be argued to say that the patent or the invention is obvious. And go back and look at those scientific arguments, sit down with your experts, sit down with these technical people within the company in the presence of an attorney so that these discussions are attorney-client privileged, and determine whether the best arguments were made. Can they be further developed? Are there other arguments that can be made to make these arguments stronger so that you're prepared for any validity challenge during the course of the litigation and there aren't any unnecessary surprises? Another thing you want to make sure is that at the time that the arguments were made before the PTO, that these arguments are consistent with the current state of the law. Will they withstand KSR, Nautilus, and Alice, and so forth? Also, in looking at the strength of your patent and determining what patents to assert and preparing for your validity challenges is to make sure that there is written support for your patent claims. Do they fall within the scope of the patent specification? Can one of ordinary skill in the art perform the invention of the claims based on the specification without undue experimentation? And also, are the claims, do they fall within the scope of the patent specification, or do they describe embodiments that are not included within the specification? You need to be aware of these issues beforehand before you assert patent claims in the litigation. And this is also the time to be considering what might happen if, what will your strategy be if an IPR or PGR challenges take place during the litigation, as your opponent might try and take your patent back to the PTO and invalidate it there. In terms of preparing for enforceability challenges, we recommend that during those interviews with the inventors and the people who have a relationship with the invention, key people who know about it, do they know of material prior art that was not cited before the patent office? You don't want to run into a situation where during the litigation, all of a sudden one of the inventors comes out with a stack of, and this has actually happened, where you ask the inventor, does he know of, did he provide any art to the patent office? And he says no. And then he pulls out a drawer and says, pulls out a stack of papers from his drawer and says, but here's a bunch of art, and none of it was cited before the patent office. But this is something that you need to be aware of prior to starting a litigation, and something that you can take care of now. Another thing that you want to look at is the patent examples, where they relied on. The data in the patent specification, do they match and are they consistent with the data in the lab notebooks that you've collected? Are they consistent with what the inventors and witnesses are stating? You want to make sure that there's no fudging of data or whatnot. You need to know the story behind the data prior to filing a lawsuit. You also want to look at the patent prosecution history and were there any statements made to the PTO that could have been misconstrued or unclear, and think about those and how you're going to deal with those issues during the litigation. And then another thing to look at in collecting the prosecution histories, as well as foreign prosecution histories, is to make sure that the representations made to the PTO are consistent with the representations to foreign patent offices. You don't want, you know, in Europe saying that the car is blue, but yet your argument in the US was something completely opposite, like the car was red. So these are things to be aware of prior to filing the litigation. Some other housekeeping items to take care of prior to filing litigation too is looking at whether inventorship is correct. Are the people listed on the patent, were they actually involved in the inventions claimed in the patent? Or were people inadvertently left off of the patent that should have been included? These are things that can be corrected now. Also, if you're going to be asserting a patent in a litigation, does the company own the patent? Have the assignments been executed by the inventors assigning the patents over to the company? And also check your small entity or large entity status. What was the status during patent prosecution? Again, correcting these things prior to filing your litigation. Now, ways to correct this, we've talked about correcting them, and there are a number of ways of correcting them. One is a reissue patent. A reissue patent application can be filed within 2 years of patent issuance if you want to broaden your claims, as long as this still falls within the scope of the patent specification. Or you may find that in some instances, after you've done your due diligence, you've determined that your claim might not be as strong as it could be. And it may be stronger if it was made more narrow and more succinct. So this is your time to go back and draft narrower claims. Also, if you have that inventor who pulled out a stack of art that was never before the PTO, this is a time to put that before the PTO as well, so that a contender later can't argue that you hid something from the PTO. And this can also be performed in the form of continuing applications. We recommend that in your patent portfolio, you always keep an application alive so that if any issues arise, you can take care of them in a continuing application. Now, a couple other things that are very important at the very beginning prior to filing suit, when you're sitting down with these inventors and you're collecting their lab notebooks, is developing the story of the invention and getting that down concrete prior to filing suit. Because once suit starts, there are going to be various appearances before the court, and the judge will often at the beginning of the litigation will ask to be educated about the issues in the case. And this is your opportunity to shine and show how important your invention is. Part of that story will be the blood, sweat, and tears that went into the invention, the efforts within and outside the company to develop it, the need for the solution that this, the need for a solution to the problem that this invention is addressing, how unpredictable it is in the field, how others have tried for years to arrive at a solution and have failed, and any sort of statements made within or even outside the company of people who are skeptic about being able to arrive at the solution. Highlighting the uniqueness of the invention with surprising or superior results. Have there been any awards or surprise about the invention? And you also want to tout any commercial success. Is it a blockbuster drug? Another element of your invention story should also be if there's to tell about the infringement, the copying of others. People are just banging down the door trying to get on the bandwagon of your blood, sweat, and tears, the product of your blood, sweat, and tears. So having that at the outset, when the judge asks you to educate them and having that ready, that gets them in your corner where they see, hey, you're the good guy, and the infringers, the accused infringers, are just trying to copy your hard work and take advantage of that. This has actually happened to me recently. In the beginning of a case, you usually meet with a magistrate to have a scheduling conference and to outline the dates of when discovery will take place. And the magistrate had 2 interns with her, and she asked us to educate the interns about patent law and about what this case was about. So I actually had 20 minutes where I could go on uninterrupted about how amazing my client's product was and how the accused infringers were simply trying to steal it. So you want to be prepared for those little nuggets. They don't always come along, but you want to be prepared early on if they do arise. And once you have the judge in your corner and they see that you're a good guy, it's going to be a lot easier to prevail over future disagreements and even during trial. Another important aspect is developing the infringement story early on so that you have a concrete litigation strategy for moving forward. Part of that story is going to be, again, defendants are seeking to capitalize on your success, taking advantage of your blood, sweat, and tears. And there are a number of ways to add to this story. Look for public statements made by the defendants. If they are touting the benefits of the infringing elements in their own products, then they're basically admitting to these elements that match up with your claims. So those are nice places to find admissions in their own public statements. Also look at, are they trying to patent? Are they trying to seek patents in the same area? Often they'll make statements in their patents that will describe their products, and you could use those statements to show admissions of that they are conceding that their product meets the claim elements. Also look if they attempted to pursue similar products and methods, or if they've attempted to design around. Any information you can glean on their products can help you in developing your infringement story. Now, another thing that you want to pay particular attention to early on is coordinating communications, controlling the flow of information among the departments and in all activities by the company. For instance, you want to make sure that if you're describing your product a certain way on its product labeling, like for instance in pharmaceuticals, that the way the product is described is covered by the scope of the claims. Does it fall within the scope of the claims? It's going to be hard to prove infringement if your product is described differently and outside the scope of your claims. You also want to make sure that any scientific data or descriptions and the examples in the patent specification, or even data submitted during declarations before the patent office, are consistent with the company's publications about the product, or product literature, or regulatory filings. You want to have a consistent story between these data points. And we touched on this a little bit earlier. You want to make sure that the factual positions that you're taken before the USPTO are consistent, or I should say that the other way, that the positions made before in foreign prosecution agencies are consistent with those positions being taken before the US. And the same thing goes with foreign litigations as well. You don't want arguments being made in foreign litigation undermining or undercutting your strategy in the US. So we suggest that your patent attorneys get on the phone with global counsel and make sure that everyone is aware of the game plan and what your arguments and strategies will be early on, so that you don't have any conflicting messages being sent out. We also recommend coordination between the patent department and the marketing department. You want to keep, again, a tight control on the flow of information. You don't want premature disclosures about the product or disclosures that could hurt the litigation. And you want to manage inaccurate development histories that could be published. For instance, there might be someone who was involved in getting FDA regulatory approval, but yet they weren't actually involved in the invention, but yet they still want some recognition for that. So you have to make sure that people aren't putting different stories out there than the actual invention story that you're going to be putting forth in the litigation. And you also want to manage your internal communications. Scientists should not be emailing each other and saying, "Hey, I just found this piece of art. I'm afraid our patent claims are going to be made obvious." You know, these are communications. People should not be talking about patent claims and patent scope and the product. And if there are communications, a patent attorneys should be present so that you maintain the privileges of that. If there are questions about things, we recommend you just pick up the phone rather than having unhelpful, untrue statements being flowing around the company. And from here, I'm going to turn it back over to Eric.
Thank you, Denise. I have one last slide. It's the scintillating topic of attorney-client privilege. Now, the title of the slide is Ask Your Attorney, and really your attorney is your sounding board, is a person you're supposed to talk about different ideas with. They're the person that's supposed to help you with advice about your lawsuit. And to facilitate that, U.S. law has attorney-client privilege, which means that communications that are in confidence, that relate to legal issues, and that were not publicly disclosed are things that never get discovered during litigation. And the privilege is meant to essentially ensure the free flow of information back and forth. So it's really a very important concept. Denise was talking about it just a moment ago. It's important that the client understands that they can't take your communications and your discussions and then discuss them with other people who are going to start commenting about them and sending them around the company and emails and things like that. Because if you disclose things too broadly, you can lose the privilege. So it's something you have to talk about with your client, but it's really a bedrock principle of U.S. law, and it's meant to encourage clients and attorneys to freely talk about different ideas. Relatedly, you have attorney work product. Work product is materials that were prepared in anticipation of litigation. So that could be some of the due diligence things we talked about before. Maybe there's some product testing that the attorneys want the company to do to determine whether or not a variation of the commercial embodiment or a design around that another company may have based upon public information would actually fall within certain parameters of the claims. Things like that. These are things that are prepared in anticipation of litigation. They have a little bit less protection than privilege, but in general, they can be protected, and in general, they can be logged and not disclose the other side. One thing that you have to be aware of, though, is that you can't go to the point where, under the guise of privilege, you are prohibiting facts from being provided to the other side. So you can protect legal theories, you can protect legal advice, but you can't protect facts. So, for instance, the date of an invention that has been developed with documentary research, like we were talking about before, you can't protect that from disclosure during discovery. You might delay that during disclosure, during discovery, because it's not necessary until certain points in the case, but you can't keep the other side from learning about that fact. There are many other facts that are similar to that. So with that, I will turn the microphone back to Shayna and see if we have any questions that that anyone has submitted from the audience.
Thanks, Eric. This is Shayna, and yes, we do have some questions. So we will now move into our question and answer portion of the program. As a first question, once a patent suit is filed, how long will it generally take from start to finish?
Well, I can take a quick crack at that, and the answer is it depends. It depends what kind of forum you're in. There are some places in the United States where it's very quick. They're called rocket dockets. You can get decisions there, for instance, in the Eastern District of Virginia. I believe it's within a year. There are some courts that go almost 2.5, 3 years before you're finished with a district court proceeding. The ITC that we talked about earlier is something that goes relatively quickly, and you'll typically get a decision there within 14 or 15 months from when you file. So there's different courts and there are different speeds, and that's something that you should always talk about with your attorney, about whether you want to go fast or you want to go slow, whether you want to be in a form that's convenient for you, provided you meet all the requirements for it, and a variety of other factors that you have to take into account before you file a lawsuit.
Our next question, during a patent suit, will the other side get to see my company's technical and financial documents?
Hi, this is Denise. So during discovery, the documents that are relevant to, like if you're accusing, let me back up. During document discovery, you will be given a list of questions from the other side of documents that they are asking for, and they should be relevant to the invention. You can make arguments if there are some questions that or categories of documents that you don't believe are relevant. We can object to those and not produce those, and they might have to take it to the court to try and force you to get those documents. But any data that's directly related to the invention, you will likely have to produce during the course of the litigation. And if you are arguing commercial success as one of the reasons why your product is so special and not obvious in view of the prior art, then you will have to disclose the financial data related to that product.
All right.
Eric, do you have anything to add?
Yeah, I'd like to interject just a little bit. There's also something that that you get relatively early in the case. Denise touched on it earlier. You're going to, early in the case, work with the other side of what's called a protective order. And what that means is that you can classify information as public information or confidential information, or maybe even have 2 levels of confidentiality for really important information. So the most important information is at the highest level, and then there's an intermediate level, and then there's a public level. So when it comes to the point where you have to produce your documents to the other side and your sensitive information, if you have confidential information, you stamp each page of every one of your production documents with a legend that says confidential on it. And by doing that, your protective order will prohibit the technical people and potentially anyone at the other company from seeing that confidential information. It depends how you negotiate it. At the ITC, it's almost always the case that your confidential information is only shared with the lawyers for the other side and not with their clients. So there are ways to protect your confidential information when you're in a lawsuit. I will say that lawsuits are a big winnowing process. So you will produce hundreds of thousands or millions of pages of documents, and potentially the other side will too. And maybe 40, 50, 60 of those are the most important things that you're going to go to trial on. And then when you have a trial in the district court, the judge is going to give you a hard time about trying to keep too much of the proceeding confidential, because the public has a right to know what's going on in the disputes. It's a public forum, and it gets increasingly difficult to kind of give a blanket designation of confidential to everything. So at that point, you have to make some decisions about what you're going to emphasize, what maybe isn't as important to keep private, and things like that. So there are varying levels of protection for the documents, depending upon how you negotiate your protective order, and also what happens when you go into trial in the district court.
A company with a patent, are there ways that the company can identify other companies that are infringing those patents? Do you have any tips on actually identifying people that you might be able to sue?
So this is Eric Fues. I would, there are a couple different ways. Sometimes, well, there's certainly the knowledge that's inside the company about what competitors are doing. Sometimes companies actually hire investigators to try to determine whether certain products are being sold in the marketplace. They usually work in conjunction with lawyers, but whether products are being sold in the marketplace that might cross over into someone's patent claims. There are also, at the ITC, surveys that are done on different types of importations that occur in each of the ports, and the information is classified by tariff code, and it's very detailed, and you get an idea of what is being imported into the United States. So there are different ways to find out if someone else essentially is selling a product that you think might infringe your patent. But before you can go to court, you have to take that information, and you have good faith due diligence requirements to try to really verify that in fact infringement is occurring. And companies and law firms can get in trouble if they don't undertake the necessary due diligence before they charge into court and allege infringement. So there are ways to get help by yourself outside, and then sometimes through discovery you get additional information, of course. But you just have to be careful in proceeding in a measured pace.
We have a hypothetical question related to startups. If a startup company identifies a larger company as a possible infringer, are there low-cost options that are available to them, for example, alternatives to bringing suit?
Yeah, this is Eric Fues. I'll try again. There are low cost. So that's really a very good question, because before you start a lawsuit, you have to determine what is your end goal. Is your end goal that you want to fight to the death and get an injunction and damages? Is your end goal that you would like to enter into a licensing arrangement with a larger company? Is your end goal that you just want to kind of protect your turf, and at a certain point you're not going to necessarily take the case all the way to trial? There are different things you really need to think about when you're starting the case, and it's often the case that a startup or a small company will have some specific technology that they think is very valuable, but they don't have the financial resources to go against a behemoth company in their same industry. And there are ways to have essentially confidential discussions. Usually you do this with your lawyer about potentially licensing your patents to the big company before you have to actually go into court and try to enforce a patent. Companies have licensing discussions all the time, and sometimes they put their best patents forward, and the other company says, well, I have my own patents and let's compare, and a business deal can be arrived at. Even if a patentee doesn't have a commercial embodiment, they can still have these licensing discussions with the larger companies. So there are ways to essentially monetize or get value out of your patents which don't involve having to go to litigation.
In a litigation, you mentioned using experts. Should companies always use an expert in a chemical patent suit? And what are the qualifications and characteristics that we should look for in an expert?
Hi, this is Denise. We recommend enlisting experts early on because the other side is certainly going to do it. And judges like to be educated by experts. They look to them to teach them about the important aspects and what the issues are. And having these enlisted early on, like Eric said, you prevent the other side from getting the best ones that are out there. And in terms of getting someone who you feel is qualified, a lot of times it's word of mouth, getting experts who have lots of publications, are highly renowned in their field, have been an expert before in trials. Those are also helpful. Someone who's experienced, because you want someone who can hold up on the witness stand and during depositions. You want someone who's confident and won't crack under pressure. Eric, do you have any other points?
Yeah, one of the things about experts is that there's always a tension between wanting an experienced expert and wanting an expert that has particular super great knowledge and expertise in your field. Some of the experts that have really in-depth knowledge in your field might not have had occasion to be an expert before. Their personality type might be that they're just fine as an expert, they're very good, or their personality type might be that they really don't want the confrontation, and it's something they're not used to, and they're not going to be comfortable doing it. Denise talked about that. But there's always a tension between, getting the experienced expert, the professor who can say a little bit about everything, versus someone who has rolled up his or her sleeves and worked in the field for 10, 15 years. They might be retired now, and they have very deep, in-depth knowledge about that particular technology. And a little bit of this plays off your judge too, because I've had judges say that some of their favorite experts are the people that have industrial expertise, and they're not interested in what a bunch of professors have to say to them about a field that they just learned about earlier in the case. And then on the other hand, you have experts that are really, really good. They might be professors, but they're really, really good at explaining things and explaining technology, and they help the court, and they can help the jury a lot.
The next question is, what is the difference between a patent and a trade secret? Is one better than the other? How are trade secrets enforced?
So I'm happy to handle that question. Inventions are, the saying is that inventions are either born a patent or they're born a trade secret. And what that really means is that, say you've invented something, do you want to keep it secret so no one else knows about it? Or do you want to publicly disclose it so that you can potentially get patent claims and keep people out of that field for a certain period of time, from filing to issuance 20 years, but it might take a while to get your claims and things like that. So do you want to publicly disclose it, or do you want to keep it secret forever? And that's a choice that has to be made very early on. Some famous trade secrets are the recipe for Kentucky Fried Chicken, the recipe for Coca-Cola, the algorithm that Google uses when it tries to search for advertisement or look at its user base or things like that. And those companies chose to keep that information secret forever, and that's their choice. The upfront costs of patents are more because you have to prosecute it, you have to take it to the patent office, you have to go through prosecution, you might have to do that in other countries. So the upfront costs are more, but then you have a kind of a finite period of exclusivity. For a trade secret, you keep it secret, but then there are other requirements that you have to do under the law where you have to limit access for anyone to just people who have a need to know about that trade secret. You have to not publicly disclose that trade secret because then it's not secret. You have to take other reasonable efforts under the circumstances to protect the trade secret. That includes during licensing negotiations and other things. So there's more ongoing costs with a trade secret to keep it secret and protected. And as long as it's secret and protected and it gives you a business benefit, then that's what a trade secret is. Then there's always the challenge of going into court and proving that someone else uses your own secret. In terms of enforcing trade secrets, the law has recently changed. You can get into federal court now on trade secrets. It used to be the case that this was exclusively state law. So I've had cases where you go into state court and you get in essentially a big line of lawyers with yellow pages disputes and contract disputes and divorce issues and all these other things. And then the judge turns to complicated bioethanol trade secrets, and it's something that they're not that familiar with. In federal court, it'll be more almost akin in terms of the proofs and things like that to a patent case. You're going to have experts, you're going to have a court schedule, you're going to finish it in your 2.5 years, and then it will be appealed at that point. So trade secrets can be protected in state court or federal court, and patents are strictly federal court.
Looking on the other side of things, what should my company do if another company accuses us of infringing their patents? Are there steps I can take now to make sure I'm not infringing someone else's patents?
Well, there are a couple of things that you should do. You will receive, quite often, you can receive a notice letter from the other side, and the reason they're doing that, frankly, is not to be nice and to try to help you work out through your problems, but they're sending you a notice letter so that they can start the period for damages to accrue. So they send you the letter, they say you infringe this patent, you infringe this claim, and then the clock starts running. At that point, you have some few options that you should do. We would recommend that you either talk to or retain a patent attorney, find out if you think that the claims against you are correct, and then you have to start assessing your exposure, because in patent law, you can get injunctive relief and damages. So potentially you could be shut out of that particular area of technology. Now, it could be the case that the patent really isn't that strong and there's a very easy design around, and that maybe it was something you even your company looked at during research and development. In that case, you might make a decision that in view of this patent issue, I have an easy design around, I'll just proceed with that commercial product. Another response would be to dispute, in fact, that there is infringement. You don't think it's well-grounded. There are even other options where you can go to proceedings at the patent office. They're called inter partes review, where you can try to essentially get that other patent invalidated because you don't think it should be out there and it should be causing you a problem. So there are a variety of ways you can respond, and you really should talk to an attorney before you undertake any of those.
And with that, it looks like we are about out of time for today. So I want to thank again Eric and Denise, as well as to our audience for joining us. And I'll turn it now back to Julie.
All right, thank you all very, very much. And a special thanks not only to those presenting today, but to your colleagues at the firm who presented the other 2 webinars. So thank you again. It's been a pleasure to be able to offer your expertise and to the GC3 audience. And finally, with that, we'd just like to remind everyone of the GC3 Innovators Roundtable on May 8th through 10th. Registration is open. You can go ahead and register online. So thank you again to all of you for presenting and the audience for your participation. And we will look forward to seeing those of you at the roundtable May 8th through 10th. Thanks again.